it's worth noting. We turned blue this last election. Prosecutors are talking about progressive prosecution. Prosecutors, I'm not sure what that means, but you know, in specifics. But when I was up there in the 80s, the defense bar was in charge of the criminal justice system in the state of Texas. It was all Democrats. So you had conservative Democrats, you had liberal Democrats, but what they put in the major committees that dealt with criminal justice issues were criminal defense lawyers. And so the Criminal Justice Committee and the Senate and the Criminal Jurisprudence Committee in the House. So you had at that time, prosecutors were not the home team in the legislature. They'd come home and be the home team. They'd be the home team in courts. But when they went to Austin, they were not the home team. And now we're switching back around to where it looks like that's going to be true, even though the state is still Republican and conservative. You can see what happened just in the last 2 or 3 weeks here locally. I think that's going to be more and more of a trend statewide. And at the end of the day, I could care less as long as they don't take away the jury trial. I get nervous when we start talking about all of the ways to work out cases that have nothing to do with reserving the right of 12 people or 6 people to decide what happens. Hey folks, how y'all? And nothing major is happening, so not only have you not missed anything, but there's nothing that bears repeating. So anyway, so now we're in this environment where what I don't know, and y'all have a better feel than I, is whether when you show up now, juries are going to be more responsive to the defense than they used to be. We went through this period of time in the 80s and 70s. Really, we had a period of very strong suspicion of the police in the 70s because of the cases I was talking about. Then we flip over to the 80s when the crime rate went up, and we come up with all of these things of mandatory sentences and sentencing guidelines in the federal courts, and all of these things designed that resulted in heavier sentences that weren't based on necessarily what was fair for the individual. On the death penalty side, people wanted to talk about life without parole, which is really a cop-out for making the decisions about whether or not to impose the death penalty or not, and in my view, imposes an incredibly evil sentence. I'm not a fan of life without parole. I think if you save somebody's life, decide not to seek the death penalty, then you got to give them hope. A system that gives nobody hope is a horrible system. That's just my view editorially. But we've had these cycles, and for purposes of what we're talking about today is whether or not, how do these cycles affect what you do in the courtroom? I'm not sure yet because it's a fairly recent thing. Is Harris County changing demographically, and will that inevitably mean changes in attitude? We all know it's changing demographically, but is that going to result in different attitudes in the jury pool we have out there? I don't know. Y'all have a better feel for that than I do, because I'm not down here in state court or criminal court as often as I used to be. I don't know the answer to that yet. But do we try cases differently now than we would before? I think my gut is going to be that you're going to find over the next year or two juries more receptive to the role y'all play if you use it right. I'm not sure that's true. I mean, I don't know whether y'all have detected any changes or anything, but it's not just the Supreme Court that looks at the election returns, but politicians look at the election returns as well. It's what's happening with county commissioners and what's happening with the judges. Is that going to also be reflected in the way juries react to things? I don't know yet. I think I want another year or two to see. I've got a couple of trials scheduled that will give me somewhat of an idea. But where does that fit in with what y'all do? Well, first of all, I don't try most of the kind of cases y'all try. So I want y'all to know that as I talk about my views of trying the cases. I prosecuted the kind of cases y'all defend, but only rarely defend the kind of cases y'all do. It's not because I've refused to do it. Those people don't show up at my door. They just assume that they can't afford me, and it's not like I'm turning them down. They're not coming in. Now, would I turn them down? Well, it depends on whether we can meet payroll and the kind of thing you do in private practice and everything. But my only point being is I'm not defending burglars caught in the building with their hand in the cash register or running from the cops after they did it. So when I tell you things, I want y'all to recognize that I recognize that you have a much harder job than I have in the cases that I have defended. My practice now is about 85% civil trial work. I'll always be very much involved in criminal cases, but it's not a high volume now, because that's where I grew up. I learned to try cases down here, and what I want to talk to you about in the time I do is things maybe that are some worth you noting. You can reject them or whatever. I think one of the biggest advantages, the reason I ask where y'all are, if you can get to try misdemeanors, it's still the best way to learn to try cases. And I think it's the best for prosecutors and it's the best for defense attorneys. And the reason is, whichever side of the docket you're on, if you screw up, the damage to your client is not as extensive as if you screw up in felony court. And trying is all about learning what works for you. I asked Jackie what kind of things it would be helpful for me to talk to y'all about, and one of the things she mentioned was what is your attitude toward juries and trial, and how do you do it, or whatever, what do you attribute any success you've had to? First of all, the reason I say how to win a case is not the right title. Everybody loses cases on the defense side. And a prosecutor that brags about his or her trial record is an asshole. I mean, really, think about it. Prosecutors pick what they try, all right? And if they think the defendant's not guilty, they're supposed to dismiss it, that they made a mistake. And if they think they've got a bunch of problems, they reduce it to such a degree that it's just irresistible to the defense lawyer, which makes it harder for defense attorneys to get to trial in the volume also. So I'm never impressed with the prosecutors talking about their trial record. Defense attorneys is pretty relevant, but it's much more relevant than the other. But I think that at the end of the day, we can talk in terms of putting our best foot forward in a way that we have the best chance maybe, but nobody should be able to stand up here and tell you this is how you win a case. Now, what I was influenced by was, I get a lot of kidding. I have a Navy blazer on now, but I get a lot of kidding about my clothes that I wear in trial. I didn't realize, there's a reason for it. I didn't realize that it had become so noticeable until years ago, representing Roger Clemens. We had this trial in Washington, and the first trial is a mistrial. Second trial is a not guilty, and so there's a big press conference. There's media from all over the world outside the courtroom. And the first question wasn't to Roger about what he found. It was to, why did I have on a Navy suit that day? And I realized that had become much more noticeable, the clothes angle for it. It doesn't really bother me, but the reason for it is when I became a prosecutor, and the same kinds of thoughts should go into how you present yourself as a defense attorney. When I became a prosecutor, I thought, I used to give talks to prosecutors and say, how many of you wear Navy suits to trial? Or these women then, you women don't do it now, but when women first started hitting into the trial world, they'd wear these dress for success suits with the bow ties, they'd be Navy suit and all, and I go, how many of y'all dress like that anywhere else except for funerals or weddings? And nobody would ever raise their hand. So why would you dress like that when you're trying to get people to relax with you, be comfortable with you, and relate to you? That's this whole way, if you ever hear anything about my clothes being a little too colorful, so that's just a personal preference, quite frankly. But my point being is that I started dressing in a way that wouldn't create, that helped not create a barrier, all right? Because I grew up hearing, you need to get in your Sunday best suit, you need to be very careful, because, and this is one thing that's different that I think it's important for you all to remember where you are now. A prosecutor has to be more careful, or they think they do. I would argue they don't, but most of them do, because they need all 12 or all 6 to agree. So a person that they offend or doesn't like them is more critical, quite frankly, than it is to the defense attorney. This is just my view. On the defense side, I'm less concerned with whether everybody likes me. I'm more concerned with whether there is a substantial enough number that they'll hold steady, because I'm going to consider a hung jury a victory. And then they got to decide whether to do it. mean, I would love to have a not guilty. That's what we're trying it for. But if I can get a hung jury, I'm halfway there. And so it's less important that there be 12 people that like me than that there be strong personalities that like me, so that I hope, if I can persuade them, they do. And my view of jury selection has always been contrary to what you hear. There are certain basic principles of trial that I think apply to the prosecution and the defense, and then we'll talk a little bit about the defense in a minute. How many of you heard you don't ever ask a question you don't know the answer to? I think that's bullshit. And the reason I do is because there are a lot of times, it's born from my days as a prosecutor, if I didn't ask the question, now it's more true for the defense attorney than it is the prosecutor. But if I didn't ask, if we've got no notice of alibi, right? If I'm the prosecutor, I've put on my case as a prosecutor, because we don't talk, I don't even know what your defense is. It turns out your defense is alibi. I don't know that. I just put on an aggravated robbery case and I rest. And all of a sudden here come 5 alibi witnesses. I don't put my guy on. And I didn't even know that person existed. So pray tell, what am I going to ask that witness if I don't ask him a question I don't know the answer to? Until 30 minutes ago, I didn't even know they existed in the world. And so that to me was always an example of you can't follow these absolute rules, people say. When you don't ask questions you don't know the answer to. It still can apply to the defense lawyer. It's riskier for the defense lawyer than it is for the prosecutor. But you can still do it as a defense attorney. You got to be listening to what they're saying. The biggest mistake trial lawyers make is they don't listen. I mean, y'all have got to, with the group that they've got now in the DA's office, which I'm not criticizing them, I'm saying it's more a matter of numbers and experience. My understanding is that the prosecutors as a whole are less experienced than most of y'all sitting here now. Is that a fair observation? If you talk about the office as a whole, all right? Whether you, for whatever reasons you give that as to why that's happened with them, it means that they are less likely to do things by instinct and more afraid to make mistakes and take chances. The truth is, in a trial, the state can afford to take more chances than the defense. If the state is afraid to take chances, that works for y'all. Let me give you an example on jury selection. The state, it goes first, obviously, but they get through and it's your turn. I want a jury to like me. I want a jury to feel comfortable with me. And I want a jury to feel like I'm not a lawyer. There was an article written a long time ago that had a picture of me which said, the trick is to not act like a lawyer. And I really believe that. That means you talk to people in a trial just the way you would in your living room. When I was in charge of training in the DA's office for a bunch of years, and I'd talk and I would say, you treat the courtroom like your living room. And to such a degree that people could almost repeat the line and see it coming when I was talking about it. But it is really true. There's no reason for y'all not to do that too. The jury wants to believe that the person that's being tried there is being fairly and decently represented. They're going to start out on the state side. There's no question about that. They're going to be on the state side. And they're going to have a bunch of presumptions. And what you want to do at the beginning of jury selection is get them comfortable with the possibility there's another side of it. And let's talk then about how you, at least my view, of how one approaches it during jury selection. I'll never forget, this had to do when I was a prosecutor, but the principle's the same. Years ago, there was a guy tried here in a series of rapes of young girls. And Ted Poe, the congressman who just retired, was the judge. And he granted a change of venue after the guy was tried here, got a life sentence, but there were a couple other serious cases. And I was the prosecutor, and we had to go try it in San Antonio. Well, one of my two biggest regrets in my life is that I never learned to play the piano, and I never learned to speak Spanish. And I'm very self-conscious about the way I pronounce sometimes Spanish words or Hispanic names. And I was all concerned about going to try a case in San Antonio. Would I fall flat on my face? You never know whether you can take the show on the road until you take the show on the road. And it was 60 Minutes was doing a show on it because the guy who did the rapes had gotten out on early release, and then he'd done 5 rapes. So it's obviously made for the media, and they're going to be there. So 60 Minutes, he was allowing him to film. This is 35, 40 years ago. He was allowing him to film through the window, but he also meant there were cameras out there when they arrived. Well, the jury came in, and I just sort of instinctively smiled as they were taking a seat. Good morning. Good afternoon. Good morning. And that was it. I never thought another thing about it. When the trial was over, a Spanish woman came up to me and said, I just want to thank you. And I said, for what? She says, well, you know, we saw all this media out there and all this big attention. We figured this was a big deal case or whatever. And we were all talking. We were really nervous. And when we walked in, you just smiled and said good morning. And we all agreed later it relaxed us. Well, I didn't think about it. Why? Because that's what we do ordinarily, right? You know, you meet somebody, you smile and say hi, good morning, etc. I never forgot it because I had done something unselfconsciously that I then started doing consciously. But the point being is that you need to think about that from the moment the jury comes in. You don't want to be angry. No matter how self-righteous you feel about your person either being wrongly charged or they're asking for more than is really fair, you've gotten close to your defendant. Doesn't matter what the reasons are and how committed you are to them. You got to remember what I always tell people, the Ronald Reagan effect. Doesn't matter what your politics are. But if you ever watched Ronald Reagan, you would see he never, ever looked mad on camera because he'd been an actor. He knew how that came across. And so he, all of those years as a politician, you never saw him in public acting angry about whatever it was that he was talking about. You got to, and I learned that